My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Are you ready, everybody? All right, listen. Will you make one cover? 1, 2, 3. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you.
Hello, lovely people. Good afternoon to you once again. Another Saturday afternoon is with us, and we're so glad and we're happy that we have come into your midst again. We're in the community, and the program is The Community and the Law. We are live on BWTV, BW Radio, on BWF Solicitors Facebook page, BWF Solicitors YouTube page, and all the other social media platforms. My name is Oreku Owusu-Frimpong, and I have the duty and the honor to host the program between now and the second and third hour of the day. So we run in between 4 p.m. and 6 p.m. UK time, which will be 3 p.m. and 5 p.m. so to speak, GMT. This afternoon, what we are going to look at is kind of a direct question. Can you still bring your child to live with you in the UK, even if you are on benefits and have 2.5 years to remain, limited leave to remain, so to speak? The answer is coming from our resource person, our guest, Lawyer Charles Asma from BWF Solicitors. So, ladies and gentlemen, my brothers and sisters, tell the other person to tell the other person that we are live. Get on board and let's do it together. It's live on The Community and the Law. Okay, we are ready. I think we can go just like this. Hello, 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 lovely people. I can see you there, and I know you can see me on your screens as well, live on BW TV, live on BW Radio. And of course, we are doing this together with BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, situated on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, North London, Seven Sisters, so to speak. BWF Solicitors have been with us and have been gracious, very, very gracious to us to give us all the time and the resources, and of course, take us into the repertoire of their knowledge and everything to tell us what is available when it comes to the law, and especially those living in the UK. Your immigration and nationality issues are so well handled by BWF Solicitors. And this afternoon, they are here with us again to give us another wonderful conversation. And the question we asking is that did you know that you can still bring your child to live with you in the UK, even though you are on benefits and with a limited leave to remain 2.5 years, as we normally call that? The question is asked. The answer is with the lawyer and the details thereof. So we will be jumping into that together. But first of all, let me tell you about what BWF Solicitors does. BWF Solicitors are trusted partners when it comes to the law. They handle immigration issues, they handle family matters. The senior partner is a member of the family panel in the UK, and they deal with issues that pertain to marriages, divorce, and all the other bits. Then again, if it is about litigation in any form or shape, they can represent you. They file appeals and they're so very well successful when those appeals are filed and the rest of it. BWF Solicitors, we say, I quote to them. And before we get into any further detail, let's say our thank yous to them and we'll be right back. Yes, sir.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited. Located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Alex Champong Ministries presents Emmanuel Praise on Sunday, 28th of May 2023 at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Hosted by Alex Champong. Guest artist, Minister OJ and Diana Hamilton. Doors open at 5. Tickets are £25 single, £40 double, £50 VIP, which includes a VIP seat, parking space, meet and greet with the artist, pictures with the artist, VIP snacks and drinks, and the £15 concession rate for children from 4 to 16. Get yours on alexichampong.com or call +44 744 741 7321. Emmanuel Praise with Alex Champong, Minister OJ, and Diana Hamilton. Come praise the Lord with us.
Hello, and thank you for having patience with us. Thank you for sticking and staying. Now, let's see who we have on and say our thank yous and welcomes. Kwame Tajima, nice one. You're watching from London, I suppose. Welcome on board to everyone, Chiwo says. The next one here, we have Jacob Stephen. Good afternoon, BWF Solicitors. Good afternoon to you as well. Good afternoon, everyone, Anaya says. So we're moving to the next one. We have James Inyewo Lema. Good afternoon to BWF. James, yes, you are with us live on YouTube. Thank you very much. Today is the 29th of April, 2023. Now, we're looking at some of the things that we can share with you as a community. Now, the one that we're starting off with is a development by Soya Nano Ghana Limited, and they are located at Dowinya Gas Oil off the Aflau Road, Tema in Ghana. Now, what do they have and what are they giving us? Now, let's look at some of the developments they have to give us. So we'll go to the very beginning and we will look at what it is they have for us. They have buildings, properties like this 4-bedroom one we have on the screen, 4-bedroom detached house. It has all the facilities you would want in an executive building. The bed they have is a 3-bedroom detached house. As you see on the screen, they can build to plan. Very stylish master bedroom, ceiling with LED and spotlights. They have a cylinder cage for the safety of your gas. There's a ceiling fan, and it's powered by solar. And you have air conditioning all over. That is the 3-bedroom detached house. They have other ones, 3-bedroom economy detached house. Well, of course, if you are a bit low on budget, this is one for you that will suit your family. 1 room and suite, paved parking space. They have plasterboard ceiling, and remember, it's solar powered, air conditioning, ceiling fans, and all the other facilities that you can really benefit from. Other ones, I think there's a 2-bedroom detached house. Those 2 bedrooms, both of them are en suite. You have your cylinder cage, yes, stylish master bedroom, ceiling with LED and spotlights, as in all the other buildings. There are metal external security doors. They have sprayed internal solid panel doors, stylish living room ceiling with LED and spotlights, as in the bedrooms. The kitchens are super and fantastic. That's the 2-bedroom detached. I think there's a 2-bedroom, the economy one as well. But these are the general features. Internal and external security, I've mentioned that. In the community, there's a gym, We have pharmacy. There's a water fountain for your Serenity. There are shops that you can go in and buy your groceries and various needs. There's a general car park for everybody in the community, a forest bar, an event center. There is a general swimming pool that you can go in there and enjoy the sunshine. Landscaping, internal road network is solid. We have electricity, as I mentioned in the other facilities that I talked about. There is solar panel power for your facilities and all that. There is also estate management services. So definitely it is one for you. So let's get some details from them. Where are they? When you use the term motorway, from the roundabout, it takes you about a few minutes, 35 minutes to get to Tema and Dowenya. And so it's not too far away from the center of the city in Accra. Remember, it is something you can get your hands on. So take their numbers now. Yes, Community 25 extension of the Aplawo Road, various housing types. Take their numbers and you will get to have the best of facilities. If you want to invest in properties, this is one I have for you. Okay, moving on the 28th of May, we are in the very last weekend of April 2023. The very last weekend of May, same slide, the very last weekend of May, we're going to have Emmanuel Praise 2023, and that's going to happen in Reading. The Pavilion, 1432145 Oxford Road, Reading, RG17UY. And it's going to feature Alexa Champong Ministry and presenting Dinah Hamilton and OJ. Now, the purpose of this program is to raise funds to buy incubators and other accessories to be donated to some hospitals back in Ghana. The very first of this program was done in 2019, just before COVID, and it's going to continue. So make a date and be with us on the 28th of May 2023 in Reading. VIP tickets going for £50, single ticket is £25, double is £40, and for children is £15. Get your tickets from alexachampon.com, www.alexachampon.com, or you can call 07447 417321, 07447 417321. So I'll be meeting you there. Yours truly will be there. So come, let's go. Praise God and also raise funds for a worthy cause. Now, if you want to write your English language, the IELTS and pass very well, I'm recommending KT Educational Consult to you. They help you pass so well. They teach you the strategies to write the English language and get the highest band you can ever get. So you pass once and for all. So prepare with the experts and pass with ease for your IELTS, B1, B2, for the skilled worker route, healthcare worker route, and all the other applications that you do for your immigration purposes. Call KT Ed Consult on 07596 620154, 07596 620154. With those announcements out of the way, let's look at our nuggets for the day. Now, during the week, BWF Solicitors threw this into the environment, and there's something for us to learn from. There is something we call surrogacy. Getting people to carry babies in their wombs for them for 9 months. They deliver and they take their babies away. Surrogacy arrangements, what are in there? In surrogacy arrangements, the rights of the birth parent are terminated and transferred in their entirety to the intended parents by a parental order granted to the people involved by the English courts. In most cases, the consent of the parent is required for the transfer to be complete. The judge must also be satisfied that the conditions of the law are met. This one is from the surrogacy consent material in literature for 2023, EWCA CIV 16. Those are references. But I'm going to go at this point in time to ask my dear friend, brother, and lawyer Charles Asma from BWF Solicitors to say this is, well, something from the law. This is something technical. This is something that we need to unpick and break down for people to understand. So, Uncle Charles, first of all, good afternoon. Thank you for joining us and welcome.
Thank you. Good afternoon.
Yeah.
Pleasure to be here.
Right. We thank God for all the mercies He's shown us. Now, we're talking about surrogacy. I try to bring it down to the understanding of my lovely viewers and listeners, where somebody will carry somebody's semen in hair or the embryo, the egg and the sperm fertilized, put in the tummy of the mother or a woman, carried for 9 months, and then the baby is born. Whose baby is that? What happens? The parental rights and everything that we are talking about here. Please, now I throw the ball back to you and tell us what it is.
Thank you very much. We will offer our greetings later on once the nugget is shared. So, viewers and listeners, today we are looking at surrogacy. And surrogacy, today we are not going to be too legalistic and technical. So, simply put, and I'm going to echo the words you used.
Right.
A is the woman.
Okay.
B is the other woman. A and B agree that B will carry A's pregnancy for her.
Go ahead. Okay.
For whatever reason. We are not going to go into why. We know that A is not willing to do that for 9 months, but is willing to commission or hire B. Let's call it contract B.
Okay.
To do that job for her.
Mm-hmm.
B accepts this arrangement.
Right.
And takes the things that will make A to become pregnant, i.e. the semen and the egg, transferred through the process of medical process to B. B carries this for 9 months. B gives birth, but the arrangement is that the baby is for A. Question: who is the mother? Who is the parent? Who has the right? Who has no right? So first off, A and B are both parents. However, because of the original arrangement, we see that B accepts that this is a pure contractual arrangement. Therefore, the presumption is that B will have no right to the baby derived from this process.
Yeah, obviously, because I wasn't able to carry that. I contract you, you've taken your money, and you've given me my baby. So your responsibility kind of ends there, isn't it?
So, generally, we'll assume
That's the
because
understanding we'll have.
because we've agreed that this is it. However, human beings as we are, we tend to change our mind easily and often, and when necessary.
Right.
Therefore, it's likely that B will change her mind to the effect that she may say, well, but there's nothing on paper. And therefore, there should be something on paper. And that something on paper is whatever B agreed to do for A, i.e., carry the baby for you, give birth for you, and I walk away.
Right.
Nothing to do with the baby. No right attached to the baby. But that ought to be by consent.
Okay.
And that consent ought to be obtained from court.
Okay.
If the consent is not obtained from court and B changes her mind, then A will struggle to say that, but this is what we agreed. That's the first point.
Okay. So obviously, then it can't be a verbal agreement.
That's what I'm saying, that human beings often change mind. And therefore, verbal agreement can be
altered and changed, argued about. Okay.
So the point here is we are looking at parental responsibility, parental right to the parental responsibility provides right to that parent.
Right.
Now, the consent derived ought to be obtained from court, as we saw, given in court. Now, once you give that consent, Madam B will have no right to the child, because we've agreed that surrogacy, once the process is over, the person, the birth parent or the birth mother, the one who carried the baby, has no right, because that right is transferred in its entirety to the one who commissioned B. So what we are saying is that the one who is behind the process
Right.
and the one who pursued the process. The one who is behind the process takes all the rights from the one who pursued
Pursued
the
process.
process.
Okay.
For the one who pursued the process is simply carrying out a duty for the one who is behind the process. However, for it to be validated and for there to be no argument, and the argument that can support the right of A, the one who is behind the arrangement or the agreement, B's consent or agreement or acceptance should be in writing and should be obtained in court.
In court. Right.
When it's obtained in court, we say that B has given consent that she will walk away from all the rights accruing from this process.
Okay.
I.e., saying that I am a mother of the child.
The child. Okay.
From this process. So no parental responsibility provided there is consent, and the consent ought to be obtained through the court process. So the question here is, if the consent is not obtained through the court process, can B have right to the child? Answer is yes. If the consent is obtained through the court process, can B have right to the child? Answer is no. And the reason is that once consent is given through the court process, B has entirely given up rights to A.
Is the consent cast in stone? I'm asking because in court there may be some agreement and concessions that I have carried the baby. I have that
Bond.
bond, that's the word, with the baby. So at a point, I could be allowed to come closer to this baby and both may agree. Would the court allow that? Or once it's a surrogacy arrangement, it's cast in stone and say that once your duty is finished, you are cut off and off forever.
So this is akin to contract,
Okay.
where A contracts B.
Right.
The derivative mother, let me use that word, derivative mother. Derivative mother is the one who has commissioned the birth mother.
Right.
The birth mother, we say birth mother because this is the person who has actually carried the baby. And therefore, whoever carries the baby is the birth mother, because the person gives birth to the child. Under the normal biological process, we say that the person is the mother. However, under surrogacy arrangement, it's a pure contract arrangement. And the reason is that A has commissioned B. A has given consideration to B. And B must perform under the terms of the agreement.
Right.
And once you accept consideration, you do not have rights. Because commission with consideration, you take what is due you and you give what is due the other party.
Right.
So you cannot then turn around to say this or that. However, because of the bond, that aspect, we say that there should be agreement obtained from court to the effect that B has entirely transferred any right that she may contemplate in future to A.
Okay.
And therefore, once that is done, no. So you can see that there are two steps. The first step is the contractual process, and the second step is the court seal.
Right.
Once the court seal is not there, B, when changes her mind, can accrue or benefit from that process. And it will be difficult for A to say that no, but we agreed this and that. Why are you now turning around?
Right.
So it has to go through the process. And once the consent, you're asking whether it's set in stone. Well, consent is when you confirm in court that yes, I have agreed for this to happen, or I agreed for this to happen. Then the consent is sealed by way of consent order, and more or less it becomes court order that B entirely relinquishes any right from or to the child to A, the commissioned, the one who commissioned the process.
So let's look at the situation. Somebody lives in the UK and would want a surrogacy arrangement with somebody outside of the UK, say Ghana, Nigeria, or any other country outside of the UK. Under what jurisdiction would these thrive? Would it be the UK because the mother That
Which of the mothers?
the surrogate mother, the birth
mother.
mother.
Let's use that simple
Yeah,
term.
the birth mother
mother.
is in Ghana, and the contracting mother is in the UK. Which jurisdiction would this thrive under?
Right. So obviously we have two points. Now, either way, the contracting mother will have to be at the other end to effect the process, so to speak. And the key thing is that it has to go through a court process. Now, we are looking at English court because there are instances where issues may go to court, and the English court wants to know whether consent was actually given in the first place.
All right.
So let's assume that there was no consent or no formal agreement in the other at the other side, and after the birth of the child, matter goes to court in the UK because remember the aggrieved person. If the aggrieved person is elsewhere, that person will go to court in that jurisdiction. If that aggrieved person is in the UK, the person will go to court go to UK court. Regardless, what we are saying is that it has to be a court process. Consent ought to be obtained in court. So the question here is, if you obtain the consent in court, will the UK court accept that order from that end of the world, so to speak? The key thing is, was there a consent obtained in court?
Right.
And if consent is obtained in court, can somebody say that because it wasn't obtained in a particular country, it is not valid? That would be difficult to say.
Okay.
So the presumption is that consent must be obtained in court. And once you obtain consent in court, court has sealed it, and therefore it becomes binding on the one who provided consent. So if the person turns round to say that I'm not happy with the arrangement and therefore I have right to the child, because of that consent obtained in court, you cannot pursue any action against the other party or the other mother.
Well, folks, if you just joined us, we are looking at the very first part of our lovely discussion, and is the nugget that is put out at the beginning of the week, and we kind of can have that explained, and we use that to apply to our situation on a Saturday afternoon on the community and the law. And this one is talking about surrogacy arrangements. The rights of the birth parents are terminated and transferred in their entirety to the intended parents by a parental order granted by the English courts. And in most cases, the consent of the parent is required for the transfer to be complete. The judge must always be satisfied that the conditions of the law are met. And Lawyer Charles Osma has graciously opened it up so very well to explain that. If you have any question, you can put that in the chat or in the comment section below, and we'll pick that one up. But in any case, we're moving and soldiering on for God, ourselves, and our survival, of course. And thank you to BWF Solicitors. BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London. Now, we know them to be so effectively efficient. So call them now, 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors are trusted legal partners. Yes, we're moving and soldiering on. We'll say thank you to them as well. The text number, I see people are sending in text, yes, already. Thank you very much. Niabwa will be coming to your text very soon. The number is 07950 422 780, 07950 422 780, or 07399 208 468, 07399 208 468, and that is for calls. And 0208 123 1016 is also the number you can call when the lines are active. But please share the page, like it, click the notification button, and also leave your comments down below. When we are live, then you can also join us and bring in your contribution. Your questions, lawyer will answer them graciously. BWF, that's what they do very well. The question we are asking this afternoon, and I'm going to go to that, is this. You have 2.5 years, which we normally call limited leave to remain. Even under those circumstances, you are taking benefits. Does it preclude you from bringing a child that you left back home to come and live with you here in the UK? Obviously, somebody would jump in the chorus and say, yes, you can do that. Somebody said, no, there are some technicalities. We may have to look at that. We need to unpick all those things. Listen, whatever your answer, let's go to the experts. But before then, let's say thank you to BWF Solicitors. And after their message, we'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, thank you very much. Now we're going straight into our discussion, and I know you would want to have answers to the question. Let me ask you, did you know that you can bring a child to live with you in the UK, even though you are on benefits and have limited leave to remain? I can hear some yeses, I can hear some no's. How do you do that? Oh, well, it's straightforward, as I can hear as well. Others say, no, let's get to the lawyer to explain. I will go with that to your advice that we're going to the lawyer to explain. Let's get back to lawyer Charles Asma. Uncle Charles, limited leave to remain, and the person is on benefits as well. Does it take the right for such a person to bring their child to live with them in the UK?
No, it doesn't.
Well, I said I could hear that chorus around. Why doesn't it? What are the rights that does it put them in different category or something?
Okay, thank you very much. Viewers and listeners, very good afternoon to you all. It's an opportunity once again meeting on this platform to share and to learn. The hope is that even if you are on a limited leave to remain or pre-settled status, you can still make an application to bring your child who is under 18 years to the UK to live with you. And even if you are not working because you are on benefit or you are in school and you are receiving student grant or student loan for your maintenance, you can still bring your child. The Assurance is that it's been done before. One application I did, it took a while. Eventually, the parent was asked to respond to an interview. He was interviewed. Father is the father is the one who wanted to bring the child, even though the mother was also in the UK. Father has 2.5 leave to remain. He works part time. He's also doing his small argument here and there. But eventually, the child has been granted. The child will be coming, I'm sure, very soon. Visa has been issued. Took a while, and this is testamental because application, we did application and it's been successful, and that is why we can confidently say that it's possible. Now,
Okay, so it's possible, and I would want us to probably look at a step back and look at that. But before then, let's take this message. Okay, now thank you very much for joining us. Lawyer was just explaining and gave a very definitive answer. Yes, you can do that. But the question I want to pose is, it took a while. There were some challenges. If we step back, was it not possible prior to maybe?
it's always been possible, but it's always a case of you making argument that meet the rules, because it is your case to prove. And the provision in consideration is paragraph 297 of Appendix FM to the immigration rules. And there are different parts. One part talks about the fact that it should be a relationship, and the relationship is that you have to prove that that is your child, and you have to that biological child or adopted child. And child means that your name is on the birth certificate of the child, or there's DNA evidence to prove that that is your child. If both parents are in the UK, it's all sometimes the case that you don't have to show too much that the other parent has given permission for you to bring the child, or is no longer in the life of the child, and therefore decision is not required from him or her, because both of you are in the UK. However, the person making application to bring the child ought to prove that they have the power to make that decision to bring the child, and that they play a key role in the life of that child. So there are instances where we have to prove sole responsibility, and instances where sole responsibility can partially be dispensed with. Now, we're looking at, so we've touched on relationship.
No.
We're also going to touch on responsibility to the child. There's absolute responsibility where both parents are in question, therefore both parents are bringing their child. Now, if both parents are not bringing their child and one parent is bringing the child, we want to know where the other parent is.
Okay.
If the other parent is in the UK, we want to know whether the other parent is aware that the child
Is being
is, and there's contemplation to bring the child in terms of relocating the child from where the child is to the contemplated location, which is the UK. Now, once we've settled that, the next point is to also look at what the person or the parent bringing the child's immigration status in the UK is. And that is where this conversation is important. Now, the point is, the law says that the other parent is settled. What if the other parent is not
It's
settled?
not settled. Yeah.
If the other parent is not settled, that means they have limited leave to remain, i.e. 2.5, they are in their 2.5 journey, or they have pre-settled status, which is 5 years under Appendix E provisions. Either way, it's limited leave to remain.
Right.
But if you have limited leave to remain or 2.5, then there is intention to settle. There's that intention that you will one day settle in the UK.
There's also the possibility that you'll not be allowed to settle.
But there's intention that you will settle one day in the UK. And you pursue that intention if you are diligent enough.
Okay.
So the point is that because of that intention to settle, even if you have 2.5, you point out that yes, you have 2.5, but there is intention to settle anyway. And therefore, you want the child to be with you in the UK. What you have is what the child gets.
Okay.
If you have 2.5, the child gets 2.5. If you have indefinite leave, the child gets indefinite leave. So there are two lanes: indefinite leave status of the parent or limited leave to remain status of the parent. Either way, there is still the case that the parent bringing the child has valid leave to remain
in the UK. No.
So that point is also settled. Now, under the sole responsibility argument, there is one part that talks about sole responsibility, that is E. And one part that dispenses with sole responsibility, that is D. So paragraph 297E says that the other parent should have sole responsibility. That means the other parent is alive. So if the other parent is alive, they have to prove that they have nothing to do with the decision, with the care and well-being of this child.
Right.
So responsibility. D, 297D says that the other parent is dead. That means we are left with one parent. And if I'm the only surviving parent, or I am the surviving parent, then I don't need any legal argument to show that I'm the only one in the life of the child.
Yeah, because there's nobody
Exactly.
there.
So you see, the law contemplated possibility of one parent being dead and both parents being alive. So where both parents are alive, you deal with E, the responsibility purely. Where one parent is dead, you deal with, let's call it limited sole responsibility. Even though there's sole responsibility, that's why I don't want to say there's no sole responsibility. You have sole responsibility because even if the other parent is dead, there might be somebody else who inherited the other parent and therefore has assumed parentage of or parental responsibility to an extent of the child. There are other family members. So we still have to prove that there is this person who makes all the decisions. But the argument is lighter because if the other parent is dead under subparagraph D of paragraph 297, and the only parent in the life of the child is the surviving parent, then the surviving parent will be the only one who will make the decision as to where the child should live. So there will be no argument of consent from the other parent because there's no other parent. So that means you have to prove that the other parent is dead. So death certificate will be necessary. So there are instances where death certificate is necessary and one where death certificate is not necessary. Where death certificate is not necessary, pure sole responsibility. And where death certificate is necessary, I will call it partial sole responsibility. Why am I not saying no responsibility, no sole responsibility? Because once the other parent is dead and you are the surviving parent, you have sole responsibility. Just that technical argument will favor you in a way. Because your argument will be that he's dead or she's dead, so I don't need anybody to decide what to do in the life of the child with me.
Now, there's this part of the whole discussion. We're talking about whether you have limited leave to remain. There are financial requirements for the parent to meet before you can bring your child in. Now, financial requirement, we have talked about the amount of money you have to receive at the end of any financial year, your savings, if there are children involved, all the calculations are there. But then we're talking about benefits, universal benefits as it is now. If I am on a condition like that, does it preclude me from doing that, does it disqualify me from bringing my child in?
Right. So, paragraph 297, subparagraph I, V, and V. One talks about accommodation, and the other talks about maintenance.
Right.
Now, we'll come to accommodation later. At this point, we are looking at maintenance. So the word is maintenance. So we are not using the word financial requirement.
Okay.
We are using maintenance requirement. Why are we saying maintenance? Because we know that the person is limited in finance.
Okay.
So if we go for full-on argument of financial requirement, we'll fail. So we have to go to the lighter argument of maintenance requirement. Because the other is 18,600, but that is for bringing your spouse. And if you are bringing a child, it's 3,200, and any other child, 2,400. So even if it's an argument of child, we're talking about 3,200, let's say a year.
Okay.
Now, if you break that down, you may still be struggling to meet the maintenance argument or the financial argument.
Financial argument.
So
Yeah.
what we say is that, you know what, right? Financial argument is that show that you have X amount, but we are not going to touch the financial argument. We are touching the maintenance argument. Because the reason for maintenance argument is that there's comparator.
Okay.
The comparator is the person in the UK who is receiving benefit and able to survive.
All right.
So if somebody is in the UK, is receiving benefit and is able to survive, how much can the person survive on? If I have the same amount, myself and my child, can I survive? Yes, you can. So it's not a matter of how much you have, but how much is adequate.
How much is adequate?
So we are now looking at adequate maintenance. So we look at the current benefit given to a parent and also a single parent with a child or a single parent without a child. For the benefit of this discussion, we've already gone into such calculations in the past when we were doing the calculations, and we did a lot of calculations on that. So we're not going to go into the calculations. I'm just going to use summaries. I may not quote figures per se. What I would advise viewers to do, if you go on the government website, just Google benefit rate for single or benefit rates for 2023, 2024, it will come up.
Okay.
You see, for a single parent with child, single parent without a child. So a single parent with a child, you should have X amount a week. Single parent without a child, you should have X amount, Y amount a week. But you can see that this conversation is not for a single parent without a child. Because the conversation is about bringing your child. And therefore, our focus will be a single parent with a child. Then we look at how many children, depending on how many children you are bringing. If you are bringing one child, single parent with one child, how much would they have for themselves and the child? Once we put that together, it becomes our benchmark. Now, the person who is on benefit, and that is where it gets technical. We have said that you have adequate maintenance to the effect that bringing your child will not be a burden on the state. Is that not the argument?
Yeah.
You have no recourse to public fund. But somebody who is already on benefit has recourse to public fund.
Yeah.
So can you argue that I'm on benefit and therefore if my child comes, we will be able to survive and therefore there will be no recourse to public fund? There's already floodgate opened for you and your child coming. But the argument is not you being on benefit. The argument is limited to you having maintenance or adequate maintenance. So if you're able to prove that you are on benefit, you are receiving X amount, that is money you are getting. You are a student, you are receiving grant, student grant, or maintenance grant, or your maintenance loan. That is money you are getting.
Yeah, getting yeah.
You have a child in the UK who is receiving child benefit. That is also money coming into the family pot. So we put all together. and assess if this person is getting X amount and is likely to continue for a while, then bringing their child, they will be able to have adequate maintenance to survive. So you have to then pull all the incomes together. Then we do the income assessment. And the income assessment is based on case law, the case of Ahmed. We talked about that some time ago.
Yeah.
So you look at what the case law says, because that is what the Home Office will use to refuse or not, or to grant. They will do the calculation and tell you that this is the calculation. A minus B should be greater or equal to C, where A is your income, B is your household expense, and here we are only limited to rent and council tax. If you take that from A, which is your income, whatever is left should be more or less than, should be more or equal to C, which is your disposable income. So we've done that for somebody who is on benefit. So if we are able to assess yours and we equate it to that person who is on benefit, then we can conclude that you have adequate maintenance.
Right.
Because we are then doing the assessment for you and one child, you and two children, you and whatever number of children. And therefore, depending on the number of children you are bringing to the UK to join you, assessment should cover that number of children. That is the point. I'm not going to quote figures today because we've already dealt with the figures in the past.
No.
However, if viewers wish to know, obviously, it's always advisable that when you are doing such application, you consult a lawyer who will then apply the threshold assessment to your case and say that before we put in the application, we should have X amount coming in or in your bank statement. Mind you, this person is not working. Let's say, because they are on benefit, they are not working. Because they are students, they are not working. So there will be no pay slip. So there will be no pay slip argument. But we need bank statement. Because the bank statement will prove that the money is actually coming in. And we use it for the assessment. And yes, so that is the first assurance.
There are several benefits and allowances that people earn in this country. I've seen bereavement benefit, carers allowance, disability leave allowance, and income support, and a host of all that. If anybody is enjoying any of these benefits, it's public funds.
It is public fund.
And the level of support that the person gives does not come into play when we're doing these calculations, whether person benefit they qualifies or not, does it?
Or the level of support the person
Like, for instance, if they have housing benefit and they pay me 20-30%.
Or you mean how much the person
how
is
much the
receiving?
person gets? Yeah.
So how much you are getting is where the focus is, because that is going to be the basis of assessment. So whatever you are getting should be equal to, of course, it is benefit, but we assume that it's your money. They'll compare it to the standard benefit of other people who are also on benefit weekly. So if we scale that down to weekly benefit, so we have benefit A, benefit B, benefit C, we put all together into one pot. And we say your income is, let's say, £3,000 a month. If you multiply 3,000 by 12, you get 36,000. If you divide that by 52, you get X amount.
For the week, how much you get?
Because benefit to individuals is given weekly. So the assessment is on weekly basis. So you have to also limit your assessment to weekly basis. So if you are getting on a month, if you are getting the payment monthly, you have to scale it down to 4 weeks so that you can divide by 4. But the reason why we don't divide by 4 is that we have different weeks within different months.
That's right, yeah.
So
obviously,
a couple of them 5.
You put all the weeks in the year together.
So you convert it to 1 year, divide by 52, then you get absolute weekly money. Once you get that, you can then compare to the benefit standard and say that what I'm getting, which is the C, is more than somebody who is on benefit or equal to somebody who is on benefit with 1 child or 2 children. Therefore, should my child join me, I'll be able to have adequate maintenance.
So in this case, whether you make an application on your own or you're going through a legal person or a lawyer, these facts would have to be laid there, and you do your calculation and see whether you qualify or not. But in a situation where you're not up to that standard, would your savings suffice to support it?
So we are looking at income. So savings is also income,
Okay.
provided that savings will be there for X number. Remember, savings, if you're not adding to it, then it's absolute in a way. And if it's absolute, how do you then say that it's going to? So how many times in terms of weeks would this be available to be able to adequately maintain you? If your savings is X amount and you divide by number of weeks, then you can say that, oh, this money will be available, can survive me for, let's say, 10 weeks. The way you are saying that if your child comes, you can only adequately maintain your child for 10 weeks.
10 weeks.
How about the remaining weeks? Is there any arrangement? That's why you can rely on savings, but again, there should be contingency plan that in addition to the savings, there is going to be cash flow, i.e. from benefit stream or from work stream or from student finance stream for a student or any other stream, provided it's going to be flowing.
Okay. So let's take it that I have 3 children back home and I want to bring them. The law says, or the situation allows me to do that. But what I'm getting as benefit will suffice for just one child, maybe. The other two, how do I prove that financially I can meet their needs?
Then technically, financially, you are not ready for 3.
Okay, so you can bring one.
From what you've told me, your maintenance is only adequate for you and 1 child.
Okay. I'm asking this question because it looks like a blanket yes, we say yes, you can do that. But technically, there may be some limitations for people.
So the question is, can you bring your child? Remember that we said child.
But I have more than one.
So can you bring your children with limited maintenance? That may be difficult.
Okay.
But we are presuming that if you are bringing, remember the conversation is all about proving that you can maintain them. So after this conversation, you realize that, oh, okay, that means what I have can only help for 1 child. Then let me do the first child. And when things improve, I'll bring the others. Or let me organize myself properly so that I can bring all the 4, all the 5, all the 3, because then I can prove that I have adequate maintenance. This is just awareness, so that you know that you don't jump into it, but you organize properly, working with the lawyer to make sure that assessment is fully carried out. The caseworker is using the same benchmark.
Okay.
So you are using the marking scheme to answer the question.
Just preempting it. And
Preempting that is going to, just what the caseworker is going to say. If they say they won't give you, because the child, if it's a child, they say no. If they say no, either because you don't have limited leave to remain or certain status. They will say no because the child is not your child. They will say no because you don't have adequate maintenance. Or they will say no because there is no adequate accommodation. I will come to accommodation.
Okay, now let's look at the accommodation situation. I have 2 children. I'm capable of proving that I can bring them in, but I have a 1-bedroom flat. Would that suffice?
So, under the Housing Act 1985, Part X, gives a threshold position for accommodation, and the policy that is a policy point, and the point is that there should be no overcrowding in any home in the UK.
Yeah.
So, what is overcrowding? Where the facility is not enough for a certain number of people. So how do we do the calculation? So Part X gives a table, number of rooms and number of people who can occupy. So for example, if you have, let's say, 4 children and yourself, making 5, you need 3 bedrooms plus a hall or a living room, so to speak. Now, there are instances where the children can share room and others where the children cannot. If the child is 13 or under, let's say under 13 years, the provision is that they can share a room.
Same sex?
Two can share a room.
Same sex, boy and
Well,
girl?
it says that if the child is under 13, the reason potentially within the thinking or the intent of the law or the policy is that at that stage, awareness is not overly great in terms of body awareness. And so if a child is 11 and the other child is 5 and one boy, one girl, under the supervision of the parent, they can share a room.
Okay.
But 13 years, regardless of the sex, you can't put them in one room.
Okay.
So that is the position.
Right. So I have a 13-year-old. I have a 15-year-old, and I'm bringing them in. The law assumes that these are two
Yes.
quote unquote adults who are body aware and would have to share or occupy separate rooms. You and your partner, husband or wife, would occupy one. So in that situation, two children, two adults, you need three beds
Good.
or three rooms. If you
you
counting
need-
the living room as a room.
Well, so you said that you need 2 rooms in terms of where they will sleep. Then the question is, what are the facilities available?
Okay.
So 1, 2, 3, 4 human beings. 2 are able to sleep together because they are husband and wife. So one room.
One room.
The other 2 cannot share, therefore, so 3. 1, 2, 3. Now, what are the facilities? The law allows for living rooms to be standalone facility in terms of bedding.
Okay.
So you count your living room as one of the rooms. You cannot count your kitchen, but you can count your living room. So if you have, so this one we need 1, 2, 3. Then we need 2 bedrooms and a hall.
Okay. Do facilities in the house count? Toilets, baths?
Well, the presumption is that there will be
Enough.
toilet facility, there will be kitchen facility. The law doesn't say you should have 2 or 3 or 4 toilet facilities. So the presumption, the status quo is that there should be such facilities, and every home will have such facility. The law dealt with living arrangement in terms of room. So if they are sleeping in the same room and the numbers are more than required, there's overcrowding.
Okay.
Obviously, when it comes to toilet facilities, you're all not going to share. You take turns. So that one, the law does not contemplate overcrowding. But where you are going to sleep, very crucial.
Okay.
So you have to then check how many people are going to live. So when somebody comes to me to say, I want to bring my child, the first thing I ask is, do you have a husband? Do you have other children already here? How many rooms do you have in the property where you live? And so if the person says, okay, there are 3 rooms in the property, the question to ask again is, do you have right to use all those 3 rooms? If the person is just renting in a shared accommodation, maybe they only share, they have 1 or 2, because at the moment it's just herself or himself with a child. And the child is under 13, therefore sharing the facility with the mother. But the next child coming is going to be, so they are going to be 3. In this case, it cannot just be 1 room, because the living room is not for her absolute use. If the living room is for her absolute use, they will add to that. But because it's a communal area, you cannot be using that.
Okay.
So we do all this assessment, and if you are not ready at the moment, the option will be to look for a landlord who will be willing to give you agreement in principle. So agreement in principle will give what we call conditional subsequent. And the conditional subsequent is that when the children come, you have the property. And once you have the property, you start paying rent. So once you have the agreement in place, and the landlord is, of course, giving you that word, you add that to your application. That is you proving the accommodation. But in your application, you have to make it clear as part of the submissions. You know, when you are making application, we have the last table which says additional information. We don't often use it, or most people don't use it because they have a letter that will do that job. But if you don't have a letter to do that job, then it's important that you set out your circumstance in that box to show how you make the rules. It is not compulsory, but it's only advisory. But all this, sometimes if you are doing it yourself, what do I write in that box? And that is why it's advisable that certain applications you seek legal advice, because you can get it wrong so easily. But the lawyer knows how to argue it out, because the lawyer will have in mind what the caseworker will have in mind in terms of assessing your case and deal with that.
Okay. Now, before I move on to activate the lines, I know people have started to call. What I will ask is that if you have a question, put it in the comment section below, whether on Facebook or YouTube, we'll pick that one up. You can call us on 07399 208 468 or 0208 123 1016, or send your text or WhatsApp message. It could be a voice note to 07950422 when you call in and we're still on a call, we will call you back or schedule something to get you to call us again. Lawyer, let me ask this, that, for instance, I've met the financial requirements. I have met the accommodation, but my 2.5 years is 6 months to expire. When the visa is granted my children to come in, what are they going to get? Are they going to get 2.5 because I was on the 2.5, or they'll get 6 months pending my renewal?
Right. So
I've got somebody on the line. Please just hold on a brief moment and let me get this response from Lawyer, and I'll come back to you.
the starting point is you give what you have. You can't give more than what you have.
I have 2.5.
So no, you don't have 2.5. What you have is 6 months left.
I have 2.5 with 6 months left on it.
No, you don't have 2.5. You have limited leave to remain, 6 months left to go.
Okay.
And because you have 6 months, that's what you have, and that's what the children will have, or the child will have.
Okay.
So if that is your situation, it will be advisable to renew it. Because as soon as the children come, if they are lucky, they have to renew. There's no point. So you wait. As soon as you renew, you make application. At least they will have, even if it takes 1 year, they will still have 1.5 years left before you are all ready to renew.
Okay. 0208-123-1016, 07399-208-468. Lawyer Charles Asma is here, and he's going to help us answer your questions. Then when we have taken that call, we'll go to the comment section and pick up the comments, with most of them are in the forms of questions and all that. We'll do that. Hello.
Hi.
Good evening, sir.
Afternoon. Hi, good evening.
Apple man.
Right. Now, I don't know about that.
Yeah, shoot on.
Okay. We'll be some Chidi and Makachi. Pacho, be that question about skilled worker visa.
Skilled worker route visa. Okay. Yeah.
Worker visa.
Okay.
Okay. It is Madam be Ghana and or apply for skilled worker visa together with my husband and the 3 children. Almost issue visa no within 4 days. Almost submitting on a Monday. By Friday, no master. Almost issue. However, almost issue my Oban and my husband. And almost catching say requesting for certain documents as part of safeguarding duties under Section 55. You know, asking for original birth certificate, you know, evidence of, you know, pregnancy records, maternity, and all of that. All of that. It's been like 4 weeks. This is what baffles me, sir. I was thinking that if they required further documents, they probably would have held everything, and then when they are satisfied, they issued all of it. But only issue the husband and the wife, and
And
held on to the children.
the ones for the children are pending.
Yeah. So I don't understand what are the implications, because number of exams there. Can they come back and refuse and then cancel DS? And I say,
Okay.
what is going on?
I think I get your dilemma. Lawyer, the
Mm.
visas for parents have been issued. The requesting data, further information for the children, would it come back to kind of bite them? Can it backfire on the adults?
Nobody knows what a caseworker is thinking.
Okay.
So I will not be able to tell what a caseworker is thinking now or will be thinking once he or she opens the evidence they have provided to assess. But we are talking about children's application, and it's very, 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 very important to the government because it's about children's welfare. So I don't know what they will come back to say. I want to believe that if they have provided what they have asked for, then it may be sufficient. But if they think it is not sufficient, under the evidential feasibility rules, they are required to come back to ask for something else. So it's always a case of when they are ready or when they are satisfied. If they are not satisfied, they will come back. If they are satisfied, they may not come back. Now, so the parents, both parents, is that the case?
Yes.
Both mother, father applying on the program.
Yes. So they all applied for the same thing.
So what I'm saying is that the husband and wife or the mother, father, so
one probably is a dependent on the other. Yeah.
Under the program. So you see, this is what happens. When they were making the application, they did not preempt and address all the child issues.
Okay.
Because even when you are submitting, they will tell you that, one, provide consent form from each other. I remember the other day I said that when we were discussing this, I said that both parents must provide a consent.
Yeah.
They have to state how they are going to meet accommodation and welfare needs of the child once the child arrives in the UK with them. They don't have to say that we are going with our child, so we know what to do. They have to separate themselves from the child and say that when the child arrives, these are the arrangements in place. Accommodation, 2-3 rooms, applying the law of overcrowding considerations. We have enough accommodation. It's going to be at this place. The child care will be catered for. I will be working, my wife will be available, or wife will be working, I will be available. Child will be going to school, will know how to pick the child from school. All this ought to be addressed. And that's why they have made reference to Section 55, quite about safeguarding argument. So, because when you are making, I'm sure when you are making the application, you did not provide all these things.
I think he's asking on behalf of somebody.
No, all of that were provided. So what they provided was they provided the consent form for both parents. They provided tenancy agreement for a 3-bed. They provided the letter from the employer supporting the application. Yeah. What they came back asking for.
Stay there for me.
Was
Stay there for me.
Sorry?
Stay there for me. So you have told me or asked that they provided tenancy, that's accommodation. They provided employer letter. That is, the employer letter is not for the child.
It's for the adult.
So that is not necessary for the child's application. So accommodation was catered for. Consent to show that, we are both aware, we give consent. But child welfare other child welfare consideration was not catered for, where the child, how the child care will be.
Would that be stipulated?
No, that ought to be in a letter.
If it's not on the form, they may skip it because they may think that it's not a requirement.
That is why, remember I said that there is additional information that you can use to address your other matter.
Okay.
Or you add the letter. Some people will add cover letters. We usually add cover letters instead of using the box, so that we can write more than what's in the box. The box can contain. So they might not. So I mean, either way, they can always come back, just to prove that indeed the child safety welfare is indeed catered for. So if you have given them everything they need, let's wait and see what they will come back to say. But obviously, there might be one thing left. That's why they came back.
I think one concern is that what would if they have cause to refuse the children, would they affect the adult parent?
No, the parent will go and leave the child. They don't have a problem with the parent. Remember, that's what they've given them. The issue is with
I
the
know,
child.
because you see, what is even concerning is that in their email that they sent to the parents, they did not talk about the welfare or the care. All they asked for was the original document, and one thing which was also concerned was education record that verify your age and who is named on the parental consent. That's what they wrote, asking back.
Are they doubting the parent of the child?
Yeah.
So
they asked for pictures from the time they were born to present age.
So
You
remember, I
know,
was asking, are these parents the biological parents of this child? And the
Yes,
answer was yes.
biological, yeah.
And they used the birth certificate,
Yeah.
didn't they?
They used the birth certificate. So they asked for the original. You know, I didn't even know there was one. Apparently, if they give birth in Ghana, there is one they give within the first 6 months. So they requested for that and they had it, so they sent that one as well.
Right. So
That
they
is
sent
color red,
so initially they sent the biometric one,
green
and they
or the
asked for
blue
the original one.
Yeah. Original
And
one.
they also want evidence that indeed this is a child growing with the parent, up with the parent.
Exactly. So they asked for pictures and all of that from the time they were born to now, which they sent us. Yeah.
Right. So let's wait and see. But remember, at the time of application, these were not submitted.
Yeah, it wasn't actually. It's not part of the requirement. So
No. What I'm saying is that at the time of application, these were not submitted. That is why they had a reason to come back to ask for these things.
Okay, so obviously we would have to keep our fingers crossed
have to
and
wait and see.
wait for what decision they will come with.
But it's not new. I
Thank
mean,
you
remember
very much.
last week we were talking about this, and it's a trend.
Okay, so I would be interested, if you don't mind, whatever decision they make, let us know, so at least we can use that.
I will. I'll follow
address
you.
other
I'll
issues.
follow you very much. So I'll let you know. Yeah.
Okay.
Yeah, there are
Follow my
people,
address
when it gets to this point, they will say that, you know what, lawyer, just take over from here and deal with them. But what you have to do is that just be tactical in your responses with them. Make sure that every request you respond. Because the moment you pause, they will make a decision, because they will give you time frame to respond.
Yeah, they gave them 10 days, which they did.
Yeah,
within
10 working days.
Now, one last thing, sorry. Yeah, 10 working days. So they responded within that 10 working days. So one thing that one of them said was, because they were worried that maybe they will sort of cancel it. They were thinking maybe one will enter and then see how it goes.
They will cancel what?
Well, I think what he's saying is they had the fear that they may refuse the children. So one will come in and the other will wait for the children.
I mean, the main applicant who is coming to work can leave.
Yeah.
The other parent will have checked the expiration of the visa. It's usually 6 months. So check when it expires. Then the first parent can come in, organize herself or himself, depending on who the skilled migrant is, whilst the other one is waiting for the outcome of the children's application. Then after that, they will come in with their child or with the children. But they won't cancel the parent visas, no.
Right.
Okay. All right. So as I said,
Thank you very much. I'll keep you posted.
Help us with that, and we can use that part of our repertoire of knowledge. Thank you. God bless you. You can also call 0739920848. We've got a few comments there in the form of questions, maybe. I'm repeating this because the previous explanation is not clear to me. My doctor qualified for indefinite leave to remain under recent changes for child born and has lived in the UK for 7 years, but Home Office issued 2.5 years. I don't know whether that's... Let's see the previous comment. It says, what should we do at the earliest to correct the mistake? My son, who is next to my daughter in age, will be 7 in December. Can we use the administrative review to correct it and apply for both of them? I don't know what your original question was. If you could help us with that, that would be
If you can
great.
call,
Or
and
if you
come
can
to
call
us.
in, we'll pick that one up. There's one here. Let me see if I can pick that one up quickly and see if we can put that one on there. This one says, okay, let's put this one here and see. I want to put that on the chat, but listen. Okay, let me read it. Let me read it. I think it will help. I'll say, can a British citizen either bring or invite her 65-year-old lonely, vulnerable mother to the UK? If so, settlement would have been the preferred choice. Which of the above options would you advise?
Well, it's not a case of bringing your mother or your adult dependent relative because they are lonely. It falls under adult dependent relative, appendix adult dependent relative. And we've talked about this in the past. You have to prove that one, they've not been well, and as a result of that illness or ailment or health impediment, they are not able to carry out daily tasks. Daily tasks include eating, drinking, dressing, mobility, taking care of themselves. If they're not able to take care of themselves, then there is impediment. And that impediment will be as a result of medical condition.
Okay.
So you have to prove it, how long it's been. So it's not a matter of word, it's a matter of medical evidence. Two, what have you done to support them in the country where they are currently living? So is there a carer? Why is the care not continuing? And so on and so forth. Other family members available, why can't they support? But they have to be here for you to take care of them. So you have to prove all this. At the time of application, you've got to support your application with the evidence. And the evidence should be historical.
Okay.
So if you're not able to do that, it will be difficult to meet the threshold under appendix adult dependent relative application. So that is the option open to the parent. Apart from that, the parent can only visit. But visit applications are discretionary. They may say no.
Okay. And it came, you've put something on there on the platform. I think there's been an answer, but I'll still bring it up here. Can students combine their long legal stay on the student or graduate visa as a continuity of stay, leading to their indefinite after switching to any form of visa?
Right. So under the graduate scheme, the intent is that the person will not have the view to settle.
Okay.
However, the law looks at continuous residence. Continuous residence, you cannot count visas, but you can count any other leave that allows you to remain in the UK, working in the UK. And therefore, if the person has been resident in the UK through different routes, then that will count towards their continuous residence.
Okay. We have one here, DHS Global Automation. You says, I'm watching program, is very educated. Please keep it up. Thank you very much. And please stay with us all throughout because we do that every week. We do one Thursday between 9 and 10 in the morning. We do another Fridays between 9:30 and 11 in the morning. And we crown it up with a community on the low every Saturday afternoon, 4 p.m. to 6 p.m. British summer time. I've got somebody on the line. Let's go to the lines. Hello, good afternoon.
Hello, good afternoon.
Boss,
my name is Jacob.
Yes, Jacob, how are you doing?
I'm all right.
Good.
I'm all right.
Yeah.
I've been part of the
let's hear
program.
your question.
Yeah. I've sent my question, but since you said you didn't understand the question, that's why I said I should call you.
Yes. Fantastic.
Yes.
Fantastic. Yes.
Yeah.
Now let's hear the original question. It will help us to look at the subsequent ones you brought in.
Okay. My daughter was granted 2.5 instead of indefinite leave to remain
Okay.
recently. And my question is, how do we correct the mistake from the Home Office? Is it through administrative review? And also, my second son will be 7 in December, and I don't know if I need to wait until she turns 7, or what should I do now to correct the mistake? Because all the family goes in for the application, and all of us are granted 2.5. But I think they should grant my daughter ILR. But unfortunately, when
How
the
old is your
application
daughter?
is over 7, it's
Over
going to
7.
8.
Was she born here
She
in
will
the
be
UK?
18. Yes, she's born. All my kids are born in UK.
Okay. So you are assuming that the change in legislation should have given opportunity to have an indefinite leave to remain rather than going the 2.5 and through that route, isn't it?
Yes,
Okay.
because in the cover letter, it was mentioned on the cover letter.
Okay.
Is this is
Yeah,
our friend on the line?
Yeah, he's on.
Good afternoon.
Hello, good afternoon.
Good. How are you?
Not bad.
Great. At the time of application, how old was your child?
She's over 7.
At the time of application, I'm not talking about today.
Yes, at the time of application, she's over 7.
She was over 7 years.
Yes.
Did you use the form that allows you to apply for indefinite leave to remain?
Well, the form that was used, it covers everybody. So I don't know, maybe ILR form was used or something. I don't know.
You don't know the form you used. And
Yeah.
so you applied for all the children.
Yes, all of us applied.
How many children?
Together. 3 kids.
Did they
2
all
boys and
get
a girl.
2.5, or some of them got 7 years? Some of them got indefinite.
No. Every one of us, all the kids get 2.5.
So they were all given 2.5.
Yes.
Did you receive a letter
including
with,
the 7 years child.
Did you receive the decision letter?
Say again.
Did you receive a decision letter for each of them? Now, when the visa is issued, they send you a letter in an email.
Yes. Yes.
Did you receive one for each of them?
Confirming the. Yeah, it was. That's what they gave to. That's what they sent to us. Every one of us got a letter to
All
state
right.
the
So
decision.
my brother, yeah, I understand. So I just want to understand something. That's why I'm asking those questions. So maybe yes or no will help, okay?
Okay.
So they all received the letter, and the content of the letter is the same for all of them.
No. The content of my daughter is different to the other 2 kids.
So what did the daughter's content say? Indefinite or 2.5?
It doesn't state indefinite.
What does it say?
It's not with me at the moment, so I
You haven't
can't.
read. Okay, so maybe you don't remember what is in it. Okay, so what I would advise is, if you feel that they have not given you what you asked for, you can write to them. Yeah, you can do. It's not admin review. You do. You can put a PAP, a pre-action protocol together, letter together, or you can simply write a challenge that you applied for this, but it's been, this is what was granted. They will come back to explain why. And
Okay.
from the feedback, you understand why this happened. But what I would advise you to do is go back to those 3 letters and read so that you have the context of the decision that was made for each of them. Even though they were all given 2.5, the explanation for why they were given 2.5 is different, isn't it? He
Yes.
said.
Well, he
Yeah.
may not remember.
No, no,
either.
like he said that they are different.
Different, yeah.
So go back and check what's there. It might be advisable to see a lawyer to understand. It might be that it is how you applied, that is why this was given. Or it might also be the case that they have made a genuine mistake. Sometimes they make mistakes as well. So if it's a mistake, then you have a recourse to challenge them. If it's not a mistake, then you may only be wasting time. So understand why, then you know what to do. Okay?
All right then. Thank you so much for the
You are
explanation.
most welcome, sir.
Okay. All right.
Oh, yeah.
Thank you
I
very
really
much.
appreciate it.
You're
Thank you.
welcome, boss. 0739908468. You can send your comment down. I can see a few of them there. Let's pick them one after the other as we move soldier on. How much do you have to pay to the Home Office if you bring in a child to the UK? Lawyer?
So how much do you have to pay?
To the Home.
Right. Maybe for planning purposes. Application for child, there are 2 parts, but the IHS, you don't pay until they are ready to issue the visa.
Okay.
I will not be able to give you a figure on top readily. I have to refer to the last application I did and how much was paid because it's quoted in dollars and it depends on the time you are paying. So work with me. Go on the internet and type UK visa fees. UK visa fees. You have a list of all the visas and how much it is in the country you are applying from. If it is Ghana, you have it quoted in dollars or any other country for that matter. That will also inform you whilst I cross-check. If you call later, I'll be able to give you definite figure.
Okay. Let's pick another one here. Covenant Grace. Hello, lawyer. What about parents? Both parents are in the UK. The mother is British. The mother has sole responsibility. The father has 2.5 years stay. The father has dedicated responsibility since the child was born. They are not partners. The mother applies for indefinite leave to enter for the child. Will the mother need consent letter from the father? Will the child get indefinite or 2.5? Well, it's loaded, but I think it's gone down some various scenarios to see where the mother or the father and the child will stand.
So mother is the one who is going to apply for this child. And can you bring it back, please? So the mother applies for indefinitely to enter for the, well, okay, I don't know what else. So what has the mother got? The mother will need, no, let's go back up. Both parents are in the UK. Mother is British. Okay, so mother is British. If mother is British, so I don't know how old the child is, but if mother is British, we also want to know at the time the child was born, whether mother was already British.
Okay.
If mother was already British at the time child was born, then we would want to consider whether the application can be made under the provisions of British Nationality Act, Section 1, 2, 3, or Section 1, 3 provisions. Now, so that's one consideration. Let's assume that the mother is going to apply for the child to join them in the UK. The father is also in the UK, so, but he says that they are not living together, but the mother will have to prove sole responsibility. So mother will have to prove sole responsibility. If mother doesn't know where father is, then how will the father provide consent? Yeah, so consent may be difficult to obtain from the father. Will the child get indefinite or 2.5? That is where I said that if the mother is British, we could deduce the child's nationality from the mother based on the date the child was born and what the mother had. On the other hand, if the child is coming to settle, because the mother is settled.
Okay. All right. Let's pick another one from there since we don't have a call yet. A single parent living with 6-year-old child in 2-bedroom flat. She's applying for 2 other children, boy and a girl, 14 and 12 years respectively. Is this adequate accommodation? I think it comes to the question I asked.
Okay, so let's look at human beings in this scenario. So we have a parent, the mother. We have
There's a 6-year-old
14-year-old boy. Well, will need accommodation, a room to himself, herself. 12 years. So the 12-year-old.
The girl will be 12.
Oh,
the
so
boy
boy and a girl. Okay. So the boy 14, 1 room. The girl, even though 12, but obviously that will be 1 room as well because she cannot share with
the 14-year-old.
the 14-year-old. So 2 + 1, 3 rooms. Then bringing 2 other. Oh,
No,
so
the single
that's that
parent
one.
is living with the 6-year-old already.
All right. So the 6-year-old. So the 6-year-old may
still
live,
live with the mother.
may be sharing a room with the mother, and therefore 1, 2, 3. Now, in terms of the room, 2-bedroom flat, I suppose there is a living room, making 2 rooms plus 4, 3 rooms, and therefore 1, 2, 3.
It could be enough for them. Okay. There's one from James. He says, I mailed to receive my BRP from the 28th of March, and up till now, it hasn't been delivered. I'm seriously getting worried.
If your BRP has not arrived, you can approach online to say that it hasn't been delivered. You can call the the delivery center, or you can call the UKVI themselves and report that it hasn't been delivered. It might be that it's been delivered, but you were not available to receive
So
it
it's been
because
returned.
it's signed for. So also ask yourself, is it the case that I wasn't available? So that you don't push the blame on them. So look at both options. And if it's a case that they came and you were not available, tell them that, well, I missed the collection, and therefore can they deliver? They can re-deliver it. So check the message received from the TNT people, because they are the people who usually deliver. And they will give you option to request re-delivery. Follow that request and have it delivered. Otherwise, call the UKVI.
Okay. One here put on there says, good evening, Kwekwe and Charles. Please, is it mandatory to do DNA to bring your child from Ghana? Her birth certificate was done recently, and the father wasn't aware of the child until when the man passed away, and family members of the man told he is the biological father of the child. The man wants to bring the child to the UK to stay with him, but he's a bit worried about if the DNA fails, because he didn't want anything to separate him from the child, since she's now her first child, as confirmed by both families. I think the question he's trying to ask is, DNA is absolute, more or less. So if it says you're not the father of a child, it will create a problem.
Okay.
And he may not be able to bring his daughter to live with him in the UK, because then it would prove that he's a father.
Right. Now, there is no law that requires that somebody should prove paternity or parentage by DNA evidence. That's point 1. The only thing that proves who the parents are is birth certificate. Point 2. The problem we have with some countries' birth certificate is how the process works. However, the caseworker cannot still doubt a competent authority's way of life or doing things. The worst case scenario is that they will say that prove that the birth certificate is genuine. Then you can go to the authorities to help you to prove it.
Okay.
However, we are looking at convenience and certainty. People prefer convenience and certainty. So if you are looking for convenience and certainty, DNA will be the best option.
Now, this is a situation he is not 100% certain.
That is
that the
why
DNA
that
will
means
prove
that means he's not looking for certainty. That's what I say. If he's seeking certainty and convenience, DNA may be an option. But under his circumstance, the first explanation I gave will be his records. So he just will have to rely on the birth certificate. However, they will ask him to prove that the birth certificate, why was it not issued at the time of birth, and what shows that it is valid or genuine. Get the authorities to provide. If the child had birth certificate, and again, who is the informant? Well, even sometimes the informant may be different from the child's parent. Again, it doesn't really matter. There's no law that tells who the informant should be. And therefore, what we are saying is that a child is born and a child is registered, and somebody will have to report the birth of the child. It's always the parent. But if it is not the parent on this occasion, so be it. But the name of the parent on the birth certificate is what we are looking at. It may be the case that he will be asked to prove certain things to show that, yes, this is a genuine child of his. But unfortunately, he has no choice because DNA for certainty and convenience is not an option. So he has to deal with the birth certificate. And whenever they ask for clarification, he should be ready to provide that clarification regarding the birth certificate.
Well, at this point, we will be saying thank you for your comments, your questions. Keep sharing. The program is live on BW TV, live on BW Radio, live on BWF Solicitors Facebook page and YouTube. We're coming your way to see BWF Solicitors are trusted partners when it comes to the law. They are at 214 to 218 Tottenham High Road, Seven Sisters. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. 0208-493-7340 is the telephone number, or 077-127-61884. BWF Solicitors. Immigration issues, nationality issues, family, marriage, divorce, property advice for here in the UK and back home in Ghana. Talk to BWF Solicitors, and tell you what, they bring the community and law every Saturday afternoon between 4 and 6 p.m. British summertime. Now, we're going to test our knowledge as to what we brought you in the nuggets. Let's read that again before we take our break. And it says that in surrogacy arrangements, the rights of the birth parent are terminated and transformed to the transferred in their entirety to the intended parents by a parental order granted by the English courts. In most cases, the consent of the parent is required for the transfer to be complete. The judge must always be satisfied that the conditions of the law are met. Now, get this at the back of your mind, and when I come back, I'll ask you a very interesting question.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, welcome back. Thank you very much for your patience, your time, and thank you to BWF Solicitors. Okay, now the question I have for you is this. Let me go pick that one up. Let's see what question we have. Right. Nana and Ifwa commissioned Araba to be a surrogate using their own fertilized egg or embryo. They all signed a surrogacy agreement, non binding in England, with Araba agreeing to the transfer of parental responsibility to Nana and Ifwa once the child was born. When AC, the child was born, Araba refused to give consent to the parental order. Nana and Ifwa brought an action in court. During the hearing, the judge was able to extract consent from Araba for the parental order. Araba appealed against the decision, saying she wasn't given enough time to consider the consent. I'm going over the scenario, very interesting one. Nana, a man, and the wife, Ifwa, commissioned another woman, Araba, to be a surrogate using their own fertilized egg or embryo. They all signed a surrogacy agreement, not binding in England, remember, with Araba agreeing to the transfer of parental responsibility to Nana and Ifwa once the child was born. We have our egg fertilized. We contract you to put it in your tummy, carry it for 9 months for us. And we agree that when your job is done and you've delivered the baby, your parental responsibility ends there. Now, when this beautiful lady, beautiful daughter, AC, was born, Araba said, nah, I'm not going to give consent to the parental order. Nana, the man and the wife, Ifwa, said, okay, well, we'll go to court. So they brought an action in court. Now, during the hearing, the judge was able to deduce that there was consent given. So he said, okay, you agree to this, that, and that. So there is parental order that has to transfer to Nana and Ifwa. Araba said, okay, judge, you said it, but I don't agree. So I will appeal against the decision. Why am I appealing? I wasn't giving enough time to consider the consent. So now three situations, three scenarios. What is likely to be the decision at appeal? One, the appeal will succeed as a consent was unreasonably extracted. Two, the appeal will fail because she gave her consent in court. Three, the court will dismiss the appeal because she signed a surrogate agreement. The court will dismiss the appeal because she signed a surrogate agreement. So three situations. One, the appeal will succeed as a consent was unreasonably extracted. Two, the appeal will fail because she gave her consent in court. Three, the court will dismiss the appeal because she signed a surrogate agreement. So now let's see what you would come up. Where are your answers? You can text that to me, 07950422780, or put your comment on the comment section down below on the page, Facebook, YouTube, or maybe you'll be daring to call me and say, I will explain the answer. Let's go that way in 2-3 minutes, then we'll draw the curtains down. Now, Kojo24 says is A. The appeal will succeed as a consent was unreasonably extracted. So that's Kojo24 saying that. Yes, text me. Let's see what you have. 07950422780, or put your answer. It sounds a bit complex, isn't it? It sounds a bit complex, but I think lawyer explained that in detail earlier on. Rebecca Marco says, number one, the appeal will succeed as the consent was unreasonably extracted. Okay, Becky, well, thank you for that. We move on to the next one. So, right after this next one, I'll ask Lawyer to come in because we're running out of time. 0795042280. Put your comments down there in the segment below. Well, let's see. Lawyer, this is an Efua and their predicament. They have agreed. You know, in the nugget, we talked about British or the courts here in the UK. But this is something that is not binding in England. So it means that it was under a different jurisdiction. I don't know. Tell me, what is likely to be the decision at appeal?
Yeah, but they said they agreed. We were not told that they agreed in court.
Okay.
Yeah, so they agreed. Of course, it's always the case that they will agree. But one is giving money or consideration. The other is accepting to do something for the other. So there was agreement. So they agreed somehow.
Okay.
But consent to relinquish any right to that process that is linked to the child should be obtained in court. That parental order should be obtained in court.
Okay.
So the question is, any agreement will be contractual agreement.
I mean,
When it comes to family law, with respect to this child, it has to be a consent from court. And the law doesn't say particular, it says consent from court. Was that agreement obtained by consent from court? No. So they agreed superficially among themselves. It's always trust, isn't it?
right.
Right. Now, at a point, there was consent from court, eventually, that I agree. Whether reluctantly or confidently or willfully.
Okay, because the third paragraph says that during the hearing, the judge was able to extract
Consent. So she has provided consent, and consent must be obtained in court, and it was in court.
or could she have asked for time to consider?
Well, it doesn't matter. She's giving consent in court.
Okay.
If she asked for time, then the scenario wouldn't say she gave consent.
Okay.
So we assume that she had enough time to think, and she gave consent in court.
Okay.
Once she's giving consent in court, consent is obtained.
Okay.
And she turn around to say no. Can she rely on any other vitiating factor? No. Whether duress or undue influence or whatever, no. You can't. You've given consent in court. So if she said, I win, then the argument would have been different.
Okay.
But she's giving consent in court. And therefore, court order, parental order will indicate that as a result of the surrogate mother's consent, an order has been put together showing that the birth parent has given up all rights to the child to the commissioning parent.
Okay.
Appeal will fail.
So, from what lawyer said, the appeal will fail because she gave the consent in court. So, the answers I got obviously were not right. The condition for parental order is that the surrogate and, if appropriate, a spouse must consent to the grant of a parental order. The consent must be unconditional, freely giving, and with full understanding. This is the Human Fertilization and Embryology Act of 2008. That's a very, very current case in 2023. Lawyer, what is EWCA?
So England and Wales,
okay. Court of Appeal.
Court of Appeal,
Okay.
civil division. But so let me let's look at stay here. The consent must be unconditional, freely given, and full understanding. We are told that the judge was able to obtain consent, and no judge will do it under duress.
Okay.
Or with undue influence. That if you do it, we'll pay you this. So give your consent. So through the process of the proceedings, the judge was able to confirm that she has agreed.
Okay.
So the judge was able to extract consent from her. And if judge was able to extract consent from her, that means she agreed to an extent, then that goes into the parental order. Now, if it's a case of she being influenced unduly to give consent, then that would have been conditional.
Okay.
Maybe conditioned to if you give, we'll give you that. But nothing of that sort can take place in court. In an open court, you cannot influence anybody. And you cannot use threats to get them to give consent.
Right.
It will be freely, and they understand that they are giving consent. And therefore, in an open court, what you say with a view to agreeing whatever happened is sacrosanct.
Well, that's it for the quiz segment. Thank you so very much, Lawyer. And it's about time we dropped the curtain and say our thank yous and bye. And obviously, traditions are not to be broken. So this is the time for a friend, trusted friend, resource person, and our teacher, Lawyer Charles, to give his closing conclusion briefly and thank you. Then I'll draw the curtain start. Right.
Thank you very much, Brakoku. And viewers and listeners, once again, thank you for staying with us through the length of this conversation. We have agreed that, yes, it is possible for somebody who has limited leave to remain and is on benefit or receiving student finance to make an application for their children or child to join them in the UK. The assessment will be based on paragraph 297 of Appendix FM to the immigration rules with respect to D. D says one parent should be dead. If one parent is dead, death certificate shows that the surviving parent is the one to make the decision. So if the parent is bringing the child, that's fine. E says that if the other parent is not dead and both are alive, then the other parent bringing the child should show sole responsibility. And that is very important. The other part is IV, which says that there should be IV and V, there should be accommodation and maintenance. And maintenance is adequate maintenance, i.e., if you are on benefit in the UK and you have a child, will you be able to survive? Yes, for a week. And therefore, if you have the same amount as somebody who is on benefit, then you can bring your child. The number of children to bring will be factored into the amount of maintenance. And therefore, the more children you are bringing, the more money you should have to be able to prove adequate maintenance. And that is case law position. In terms of accommodation, we've concluded that Part X of Housing Act 1995 requires that there should be no overcrowding. And therefore, you have to show that you are not going to create a nuisance in your home or overcrowding in the home by bringing those children. In this case, you have to show that there's enough rooms in the property, and this can be obtained from Part X. So the more children you are bringing to add to yourself and other children here, the more rooms you will need. We've concluded that if the child is 13 and above, they will need their own room. We've also concluded that mother, father, or parents can share one room, and one parent can also have a room. Therefore, under 13 children can share rooms, 2 per room. And this is how you do the calculation. And once you're able to do all this, you should be able to have your child to join you. If you have indefinite leave to remain or British citizenship, the child will have settlement. If you have limited leave to remain, depending on how many days or months or years you have left, that is what the child also gets. Children's applications are always technical due to safeguarding needs of the child, and therefore it's important that you take time to apply when making such applications. If in doubt, please consult a lawyer, and that will do the trick for you. Thank you once again for making time with us. Join us again in the course of the week, Thursday, Friday, Saturday. Thank you.
Well, thank you so very much. I have Thomas Jimabuachi. You're asking a question, but I think I will transfer it to the lawyers for an answer later on and maybe pick it up next week. It says, good evening, Kweku, please kindly, one question. If my mother is visiting, with 5-year visa, can I apply indefinite stay in the UK for her? Now, keep your fingers crossed. I'll pass that over to the lawyers for them to answer for us when we come next week. So I'm inviting you to join at the same time next week for another edition of the Community and the Law. Now, this afternoon, we asked and answered the question, did you know that you can still bring your child to live with you in the UK, even if you are on benefit and have 2.5 years leave to remain? Answer is yes, you have to do it right. But as lawyer advice, whatever it is, if you can, seek the services and the assistance of a lawyer who can do that very well. When they do put in the cover letters, it's so well detailed that it's often not disputed and your appeals applications go through. On behalf of everybody that's been part of the program, my producer, Professor Ade, Sheila Nkra, Padmodu, to the lawyers at BWF Solicitors, starting from Uncle Ben, Uncle Charles, Uncle Richard, and also to Auntie Cynthia, Auntie Eunice, Lawyer Eunice. You meet Lawyer Eunice every Thursday morning, 9 o'clock with our Sidri Prophet, and Friday, now is always on there to host the program, and I come in to round it every Saturday afternoon. So I'm inviting you to come join us live on BWTV. Once again, my name is Yusuf Rimpon. Have a very good week. We're starting a new month come Monday. And listen, 5 is a good step to take. God bless you. I'll see you next week.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, oh, oh. Oh, oh, oh. Everybody say, ah. Say, how can I express my gratitude for all the many things